Kia ora everybody. Anō he kataimai te tepu. Tatana ka riri anga te kaupapa o te kraune ke puta nā kōrero mo tātou koto. Hoi anō e tātou mā. Can we get our ears on please and let's be kind to the Crown. It's just, I know it's very hard, but it's just a sign of accepting. It's peaceful, we're showing kindness, and we behave in the manner that our great ancestors have behaved, the great chiefs.
Kia ora, Owen. Tēnā koutou.
I've got one pānui.
Oh yes, one pānui.
There's a hui, te kotahitanga ngā hapu, ngā puhi. The hui is on 24th of October, 10 o'clock. At Pukapu Centre in Kawakawa upstairs. Hoi anō tātama, Judge. Thank you.
Okay, kia tau. Kia ora tātou. We'll start again. Mr. Hill.
I believe we left off at paragraph 156.
156. Kamo.
The development schemes seem to have helped Northland Māori retain their land as well. First of all, there were no private sales of land under development schemes. And I would add here, and I think I flagged it earlier, that the gazettals appear to have slowed private sales throughout the district during that period as well. Some development schemes, such as Te Horo, actually acquired additional general lands over the course of the scheme. John Davis was cross-examined on the land board's acquisition of blocks of general land for the Te Horo scheme in 1977. And I have an excerpt from that. You talk about purchases of 4 blocks of land by the Māori Land Board on behalf of the Te Horo owners. Those are the salary blocks, is that right? That's right. And were those blocks general land? They started off as general land. And then they were amalgamated into the Te Horo scheme.
Sorry, can we just have some quiet, please? There seems to be a few people over here having their own hui. Can we just... We can't hear the kōrero. Kia ora.
They started off as general land. Question. And then they were amalgamated into the Te Horo scheme? Answer. They were amalgamated into the rest of the block. Question. And that was about 1977 also? Answer. Yes. Question. And then just down at 6.52, you say that you supported the purchase of those lands and the amalgamation of them into the scheme because it would stop them from being lost to European farmers. Is that right? Answer, definitely yes. The Crown submits that the development schemes assisted Northland Māori in not only retaining their lands, but in cases like Te Horo, sometimes adding to them. The claimants, however, allege that while there was no private purchasing, the Crown acquired half of the land that was put under the large development schemes. It appears that the Crown purchased 3,508 acres outright and also acquired individual interests in land equal to 10,688 acres. And those figures are taken from Ms. Bassett's report. However, the outright purchases were intended to facilitate the establishment of Māori farms. Ms. Bassett confirmed in cross-examination and in answers to written questions that 1,255 of those acres purchased outright were settled with Māori farmers. Over the page to paragraph 160, in terms of the interests acquired by the Crown, Ms. Bassett confirmed that the equivalent of 5,045 acres, so roughly half of those interests acquired, were ultimately directly revested in Māori ownership. This included all of the interests that the Crown acquired in the Te Horo and Oromahoi schemes. As of 2014, the balance of the interests acquired by the Crown equal to 5,643 acres in Awarua, Naiotanga, Omapare, Rangihamama, was held by the Maori trustee in trust for the beneficiaries. In short, the Crown did not come away from the development schemes with substantial land interests or interests in land. Instead, it returned the interests it acquired and wrote off millions of dollars of debt. Indeed, throughout the entire period the schemes were operating, the Crown had the legal power to enforce mortgages it held over those indebted properties and acquire the land that way. It never once exercised that power. Overall, the Crown submits the development schemes were a good faith attempt to promote both the retention of Maori land and its utilization. Ms. Bassett agreed when cross-examined about the Crown's intentions behind the schemes. Question, would you accept that there were genuine intentions in this behind the enactment of the 1929 legislation towards Maori generally? Answer, yes. I do think that Apirananata in particular was trying to address this long-standing problem. Question, and do you accept that those genuine intentions were also intended towards the Maori of this district that this tribunal is considering? Answer, yes. The Crown acknowledges that the development schemes were not as successful as intended by Nata and other early proponents, or as successful as was anticipated by Northland Maori. Nicholas Bailey observes in his report, quote, the major change that occurred over the lifetime of the development schemes was the limiting of expectations. As part of Nata's vision, it was hoped that these schemes would become a major vehicle through which Maori economic development could proceed and cultural and social values be safeguarded. However, while development schemes provided a vital source of employment during the Depression, they did not provide the platform for long-term development and prosperity that Nata had hoped. Nata's vision for land development as a source of long-term prosperity for Northland Maori was simply not attainable, regardless of what the Crown did or did not do. This had more to do with changes in the nature of farming and farm labor than the operation of the development schemes themselves. Again, Bailey describes, and I've already quoted this, how commercial farming had come to rely on less and less labor and was a diminishing source of rural employment. He concludes that even if, quote, even if Maori farming had been remarkably successful after development scheme assistance, it could never have satisfactorily addressed the employment needs of Te Raki Maori. In his testimony, Leon Penny described the changing economies of scale for Maori farmers in Northland after the Second World War. Question, you say in paragraph 10 of your evidence that after World War II, the size of individual lots became uneconomic and it became increasingly difficult to keep up with such things as mortgage repayments. Do you know why that was? What was the change after World War II? Answer, be just the economies of scale, just that period where the 30-acre unit became uneconomic, and as today, so the 300-acre unit wouldn't be economic now. Question, right. Answer, it was 30 back then, 300 now potentially. These changes in the economies of scale and labor requirements in farming were particularly problematic in Northland, given how rural the Maori population was throughout the 20th century. According to a 1958 study by R.M. Fraser, which is dealt with in Mr. Walzel's overview report of the 20th century, Northland Maori were far more rural than their Pakeha counterparts in Northland. 83% of Northland Maori lived outside of boroughs, as opposed to 57% of Pakeha. When the Maori population began to rapidly increase at the beginning of the 20th century and accelerating in the mid-20th century, further pressure was put on rural areas and the dwindling employment opportunities in them. These were factors outside of the Crown's control and could never have been fully addressed through the development schemes as Mr. Bailey has concluded in his report on economic aspects in Northland. And these issues are further discussed in the Crown submission on issue 12. The next session I would have taken as read title reform. As I've noted, the Crown has conceded that the compulsory acquisition of uneconomic shares was a breach of the treaty. This describes the legislative reforms that led to that. I would take you now to paragraph 180 to describe another aspect of title reform, being amalgamation and aggregation. When the titles of two or more blocks of land were canceled and a single title issued for the whole of the area concerned, it was called amalgamation. For example, when the Te Horo scheme got underway, 62 separate titles covering some 7,200 acres were covered by the amalgamation order. Amalgamation was often used in consolidation schemes and was much favored in the post-war era as a way of creating productive properties by amalgamating adjacent uneconomic farms. And as we've just seen from the testimony of Leon Penny and the report from Nicholas Bailey, the size of an economic farm was changing as developments were being made in the nature of farming. So it was a moving target. This was affected by order of the Native Land Court under Section 435 of the Maori Affairs Act 1953. And I've excerpted that section there. Over the page, owners could object to their land being included in an amalgamation, and the court could, if it desired, exclude the land of any dissenters. Those who were unhappy with the decision of the court could also appeal against it. Owners could also reject an amalgamation proposal before it got as far as the court. And those propositions are taken directly from Ms. Bassett's report. Leon Penny described how individuals on whānau made different decisions about whether or not to join the amalgamation of the Oromahoi block. And I've excerpted the cross-examination there. Question, you talk about some owners or many owners giving approval for their lands to be amalgamated. Do you know how many blocks were amalgamated into that scheme? Answer, that's a very good question, and I don't know the answer to it. I'll be over 10. It was really whānau based to a certain extent. The wider whānau had their individual 30-acre lots, and not all those lots came back. Some of them still remain with the whānau now, some of them even to the extent that they're surrounding our block, which are a larger, in my evidence, there's one in particular, I won't name it, but it's reverted back again because it wasn't quite economic in itself. Right, but still not big enough. They've approached us to come back to us with us now. Question, so it's your understanding that some whānau decided not to amalgamate their answer? Yes, some did. But there are also some whānau decided to amalgamate part of their blocks and not the entire amount. Question, right. So, answer, so well probably considered there'll be a number of lifestyle blocks there now, some reasonable size, yeah, the majority of the area was amalgamated. Amalgamation, where it was employed, was entangled with land development and with the conversion of uneconomic interests. The evidence laid before this tribunal is not detailed enough to allow the impact of amalgamation to be separated out from the impact of land development and the conversion program more generally. It seems from the number of schemes that involved amalgamation that Northland Māori accepted it as a necessary means to achieve consolidation and to facilitate development schemes. Now I'll move to the trusts and incorporations section, and I believe this in part will address one of Dr. Anderson's questions from issue 5. Over the 20th century, the Crown developed legislation, and it's probably more correct to say at the end of the 19th century as well, to allow for the creation and operation of Māori incorporations and trusts as potential solutions to the difficulties with Maori title. These have proved to be durable mechanisms for decision-making about land and its administration. Indeed, by 2008, they accounted for the majority of Maori lands in Northland. Section 122 of the Native Land Court Act 1894 allowed Maori landowners to make an application to the Native Land Court to establish a body corporate if a majority of the owners agreed. Section 123 gave the owners the power to establish a committee of management, and Section 126 gave the management committee the right to alienate the land by sale, lease, or mortgage. There were various amendments to those provisions over the course of the early 20th century, and I've outlined those in the subsequent paragraphs. Incorporations in Northland, if you go to paragraph 194. When the Stout Nata Commission investigated land in Northland, it recommended that 3,367 acres in the Hokianga County be incorporated. In the Bay of Islands County, by comparison, it recommended that 22,000 acres investigated be incorporated. Overall, the percentage of land to be incorporated was 5.7%. Now, according to Dr. Hearn, none of the blocks identified by the Commission were in fact incorporated at that point. And indeed, it appears that little use of incorporation was made in Northland during the first half of the 20th century. There appear to be no pre-1950 mentions of incorporations in Bergen's block histories. Dr. Hearn mentions a 1908 application to the Native Minister for incorporation, but apparently that came to nothing. And Mr. Waltzel mentions some mid-1950s discussion about the possibility of forming a corporation in the Pangaru project, but it's not clear whether that ultimately was done. Nevertheless, by 2008, Taitokoro had 15 Maori corporations, and these incorporations accounted for 33,801 hectares, or 83,525 acres, which is 38.7% of all the Maori lands in the Taitokoro district. Although land holdings by incorporations are substantial, overall, Northland Maori appear to have preferred the trust model, and I'll get to that shortly. There's evidence in the inquiry on the creation of the Tapu Waitangi Incorporation in 1965 and its role in retaining Ngāti Rehia lands. The incorporation appears to have struggled with low returns from long-term leases and losses in farming, but has been successful overall in its primary purpose of retaining the land. And the cross-examination of Mr. Hohaya shows this, and I've excerpted it at paragraph 199. Question, but the land has been retained since then, being the 1960s? Answer, the land has been retained, yes. Question, and did the corporation develop the beachfront properties? Answer, they developed the lease properties, and then they were sold on, and the buildings were built by the people that bought those places. And what kind of titles are those? Do those properties have? And there's some clarification about that question. Maori freehold, I think. I'd have to go back and check, but I'm pretty sure. No, the leasehold on Maori freehold land. Correct, yes. Answer, so they are leases on Maori freehold land, but the incorporation still owns the lease. Question, and that is the same with the farmland, is Maori freehold land? Answer, it's all Maori freehold land. According to Mr. Hohaya, as of 2009, quote, the incorporation had come to a point where the vision of retaining the land was secure due to the lease income being able to meet our operational expenses. He described the current state of the aspirations of the Tapu Waitangi Incorporation as, in June of 2012, we developed a 3-year strategic plan. The plan is focused on our business development towards providing the platform to realize our long-term aspirations to find optimal uses of our farmlands where we would look to diversify. Such areas of interest include cultural tourism, creating more coastal properties, and investing in industries that require people. This will promote growth and employment for whānau and provide the means to reacquire our traditional lands to further develop as an economic powerhouse. Now, trusts. Section 3 of the Native Land Laws Amendment Act 1897 allowed Māori to convey land to be held in trust to the Surveyor General. So this is the early stage of developing trusts. But if you go to paragraph 2003, I deal with the 1953 legislation. The Māori Affairs Act 1953 created a new system of trusts, the so-called Section 438 and 439 trusts. The Māori Affairs Amendment Act 1967 expanded the provisions relating to court-established trusts for the ownership and management of Māori land. Section 438 and 439 trusts were the dominant structure for trusts for the management of Māori land until the introduction of the Te Ture Whenua Māori Act in 1993. In the 1970s and the 1980s, Māori made use of the Section 438 trusts as a means of controlling their lands. And by 2008, there were 517 trusts in Taitokoro managing 53,454 acres or hectares, which is equal to 132,088 acres. Leon Penny gave evidence about the operation of the Oromahoi Trust. When the trustees took over the block in 1990, after it had been returned from a development scheme, they were able to borrow from the National Bank, giving security over the assets of the trust as opposed to the land. They've since been able to acquire investment farms, invest capital in subdivisions for Papakāinga development, improve paddocks, water reticulation systems, environmental cleanup efforts, and educational opportunities. And I have an excerpt from his testimony there. Now finally, the Crown acknowledges that some of the changes in land legislation from 1909 to 1967 resulted in further land loss for Northland Māori. However, as I've described in these submissions, many of those changes were actually intended to promote retention and development. The Crown cannot foresee all of the outcomes of its policies and unintended consequences of forces outside its control.
Mr. Hill, can I stop you there, because you've said this before, and you know I take what you're saying, but one of the things that they could see, especially in the earlier period of the 20th century, was that Māori control of their land was being diminished, and also that within that structure that was created, the land board structure, that Māori participation within that land board was also being diminished. And then this is at a time when they've already compromised to reach the 1900 Act. So it's at a time when they're actually being led to expect something quite different.
Yes, and I think if we look, and unfortunately we skipped that section, the timing from, I think the operative period is from 1900 to 1913. And from 1900 to 1905, you have the operation of Papatupu block committees, which are conducting the investigations and then having those confirmed by councils. There's the ability to raise funds by the councils to provide loans to Māori owners, and that overall was viewed as an appropriate response to some of the difficulties that had been raised in the past and the problems with land ownership.
Maybe not, not the perfect response.
Not the perfect response. And in 1905, with and the name escapes me, I'll go back to my submissions, the Amendment Act that comes in, the view then is that one of the enduring problems is coordinating, making collective decisions about use and development of land. And so the concept of vesting, whether voluntary or involuntary, is introduced at that point. Finally, in 1907, there is active compulsory vesting. The view there being that this is ultimately in the best interests, maintaining retention of Maori land, retaining it in Maori ownership while allowing it to be leased, that would obtain a good return. While misguided in retrospect, that appears to have been the intention. So again, the issue of lack of control, I take your point.
But it's not just about the compulsory vesting, it's about who's on the board and the Māori versus Pākehā balance within that structure.
Yes, I take your point on that. And I would just remind you that by 1913, so shortly after, five years roughly after compulsory vesting gets underway, it's abolished. And while some of the lands that were compulsory vested still remain under these 50-year leases, the process of compulsory vesting is abandoned and statutorily removed.
But at the same time, other measures that were potentially protective were also removed in that period. And levels of sufficiency, what was considered sufficient, had been reduced at a time when you were saying that the economics of farming actually demanded more, beginning to demand more. So you have to factor those changes in as well, don't we?
Yes, I would take that point.
All right, thank you.
And perhaps one could add to that the further change of the demise of the Papatupu committees under the Māori Land Administration Act, which of course Māori had embraced in the north with great enthusiasm and put a tremendous amount of effort into them to make them work. But again, the Land Court was still there on their shoulder, and they still had, there was still had appeals to the Land Court. If they went through the council or the board decisions, then they went back to the Land Court. And finally, they didn't really have the power to settle titles. And of course, that whole experiment, as the government saw it, was quite short-lived again.
But by the end of it, the majority of customary land had passed through the court, was titled. So at the beginning of 1900, I don't know the exact figures, but there was a substantial amount of customary land still that hadn't been clothed with title. By the end of the Papatupu block committees who were inquiring into the ownership of those customary lands, there was very little. So on the second point, I would say that in answers to written questions, Mr. Hamer, who had prepared his report with Mr. Meredith on the Papatupu block committees, I think agreed that the Native Land Court and Native Appellate Court in those cases, while it still existed as a possibility for rehearing and appeal, their evidence in their report is that largely it was confirming the decisions of the block committees and promoting the arrangement or settling of appeals outside.
Yes, but it made the whole process very long-winded and very exhausting, I think, for those who were involved in it. And then, you know, I don't know that those who agreed to the setting up of the committees had considered that the committees would be gone so quickly.
On the availability of rehearing an appeal, I would just note that if Parliament had passed an act and the Crown had promoted a system that didn't allow for rehearing or appeal, that would raise problems as well.
Yes, but could it not have been done internally? I mean, why did you always have to have the court ready to do that final step?
I take the point.
Oh, sorry.
Yes. I'll take my final section as read and invite any further questions from the tribunal.
Well, perhaps, Mr. Hill, if I could just go back to page 22 quickly. And this is in relation to vesting, paragraph 55. You said very little land was vested in the Tokoro Māori Land Council, and the Ngāta Commission concluded that legislation failed because Māori did not wish to surrender the management of their land and were suspicious of the government's motives in setting up the land councils. So that, again, casts some doubt, I suppose, on how wholehearted support was at the outset for these new councils. And of course, it was later increasingly so for the boards. But the other aspect of that was, to some extent, people were starting to bring their land to the land councils towards the end of their life, as it were, without knowing that was the case. So the government, again, didn't really give them time to get off the ground properly or support them. Was that fair enough?
You're speaking now of the land councils and Papatupu block committees that were set up under the 1900 legislation?
Councils, yes.
I don't have a ready comment on that.
While Dr. Parsonson's looking through her notes, one thing you've talked about is the effect in terms of land retention, and that sometimes it assisted it. But aren't we in a case when we look at these various processes like amalgamation and the development schemes, that you end up a situation where, especially when they're brought to an end, some Māori end up being winners and some Māori end up being losers, and that this has actually ended up in a lot of distress and emotional division within certain hapu and even in certain whānau.
I think there's certainly evidence of that in the inquiry. Yes, I would agree. I think, again, it underscores the tension and the complexity of trying to address fractionalization of interests that occurred in both the 19th century and continue to occur through succession in the 20th century.
Yes.
I would say, however, we can't judge the legislation, the actions of the Crown simply based on the results, the ultimate outcomes, the amalgamation, consolidation of titles, and trying to facilitate development through them and coordinate decision-making about land. Those were all things that were being asked for and pointed to as significant developments to deal with the perennial problems with Maori title. How they ended up in once interests in the land were vested in trusts and the conflict and dissatisfaction that ultimately resulted, I mean, those are effects that perhaps were not foreseen when the immediate goal was overcoming the fundamental problems with fragmented interests and the uneconomic units that they generated.
I suppose when I did write in my margin here that the nursery rhyme, there was an old woman who swallowed a fly, who swallowed a spider, who swallowed a bird, who swallowed a cat, who swallowed a dog.
I hope that finds its way into your report.
All right, I don't really expect you to respond to that.
And just going back, Mr. Hill, to page 29.
Sorry, page 29?
29. The bottom of the page, you say Dr. Hearn concludes that the figures show that much of the land vested in the Land Board was left idle. Is that right? That's the case?
That's part of his conclusion, yes.
Yes.
I'm not sure. What he's looking at is the Royal Commission's report of 1951 and the current state of vested
Yes.
lands at that time.
Yes.
What I don't have figures on leasing through the intervening 45 years.
Yes. Well, I was just thinking that the Stoutnata Commission, again, saw the land boards as having a fiduciary duty in respect of land vested in it. And Ngata waxed quite enthusiastic about the active role that the boards would play in selling and leasing land and being able to raise mortgages and develop land. So when you see that a lot of it just sat there, you wonder if, in fact, I mean, what were the land boards to some extent in dereliction of their duty?
And I would just say that there were also factors outside of their control. The take-up of vested lands through leases at the height of the Depression was difficult. There wasn't much market for them. Wider economic trends also affect lessees, and general downturns in the agricultural market. Things like that could not have been foreseen at the moment that the lands were vested in the early 20th century. We then enter into a period of prolonged economic stagnation. So a fiduciary owes obligations, yes, but they're subject to what's reasonable and what's possible.
And you've talked about the development schemes and some of the things they achieved. And I just wanted us to remember that we've had a great deal of evidence in this inquiry about things that they didn't achieve as well. Sometimes quite painful evidence about the way in which Māori Affairs managed the schemes and insisted on what people regarded as poor farming practices, on the debt piled on to schemes, which by, say, the 1960s had become very high, that people felt completely shut out often of control over their farms, and the feeling that, in fact, was expressed to us on a number of occasions that the debt that was piled onto the farms was a way, in fact, of Māori Affairs keeping control of the land. That was the perception. And of course there were those who had to leave their lands as a result of amalgamation. So those are the things that we have to weigh against the types of success that you've brought to our attention.
Agreed, and there is certainly evidence in this inquiry of those types of drawbacks and complaint about the development schemes. I would point out that other tribunal panels have weighed this up as well, and at paragraph 18 I summarized their findings. In the Central North Island report, the tribunal found that the principles of the treaty did not require the Crown to ensure the success of the development schemes, and that it was not reasonable to expect the Crown to have foreseen all the challenges that arose with particular development schemes. The Crown's obligation was, according to the tribunal, to enable participation, not to ensure success. Also, the tribunal observed that development schemes were an important and practical Crown initiative to assist Māori to overcome barriers to the use of their land for farming. The Hauraki report, in that the tribunal observed that a range of factors outside the Crown's control affected the success of the schemes, including wartime shortages, economic pressures, urbanization, and declining rural employment.
Yes, well, I think when we are considering the development schemes in Te Raki, that is exactly how we will look at them in their own context here. I suppose just a final question is, again, you've accepted the long-term consequences of the Crown's title system, and you'd accept that the prejudice from that has lasted a very long time, and by the time that we get to the mid-20th century and conversion is being considered, it's very clear that the title system really was not serving Māori at all, in the sense that there were incomplete lists of owners that was very widespread. There was unsurveyed land, there was lots of unregistered land in the land title system, and that people did not have secure registered title to their land, which had been, I suppose, one of the things that the government had initially thought would happen or hoped would happen. The rights of successors, of course, were overlooked in the rush to conversion, so that even though people might have very small property interests left, and these were the people who had managed to hold on to them, in fact, then they ran headlong into conversion, some partly compulsory in some senses, but also the live buying determination because the government was completely focused on reducing small interests in blocks. And it became a sort of article of faith that that was how you had to do it. And it wasn't really till considerably later, perhaps, the Land Court Commission of 1980, that there was a reassessment with Judge Jury of saying, well, why do people have to lose all their interests? But of course, a lot had by then. So I just wanted to ask if the Crown accepts, I suppose, the broad way in which people were prejudiced intergenerationally by the way in which the title system and the emphasis on individualisation continued for such a long time.
In my issue 5 submissions, I said how I tried to underscore how wide-reaching the concession about the nature of individualization, its effects in fragmenting, fractionalizing land.
Yes.
And the Crown has framed that in the failure to actively protect tribal structures and systems of communal tribal decision-making. Of course, that has long-standing and wide-ranging effects.
And prejudice too.
And the prejudice is acknowledged as well.
Thank you. Thank you.
Thank you, Mr. Hill. We now move to issue 8, and it's the amended version.
And the number for that amended version, Your Honour, is 3.3.405B. Well, members of the Tribunal, this issue is the issue relating to public works and undertakings. And the nature of this issue is that it is particularly fact-dependent. The evidence before the Tribunal, particularly the report of Mr. McBurney, goes through a number of case studies, and the generic closing submissions for claimant counsel go through the individual takings that Mr. McBurney has reviewed and has made submissions about those. And
excuse me, Mr. Irwin, before you even begin, I was quite interested in the approach that the Crown has taken on this particular issue. Because when I read this, what I didn't read, it did seem very focused on Mr. McBurney's report, and of course it's entirely up to the Crown to do its submissions as it thinks best. But I couldn't really, we heard so much from the claimants about the impact of public works, and also within the specific submissions. And so I ended up being perhaps a little distressed, if you like, in reading these submissions. And I just wondered whether you had a comment on that.
yes, members of the Tribunal, in the time that was available to the Crown between the filing of generic submissions and specific submissions, the Crown team's done its best to prepare its submissions on each of the issues. And on this issue, it's gone through each of the points noted in the generic submissions, and there are many of them. This in itself is a fairly comprehensive submission addressing seriatim, the case studies identified. and there wasn't time. It just wasn't feasible or possible for us to go through all the specific submissions. It really came down to an issue of time for us.
Because, I mean, it does have a bit of a downflow effect in terms of what you've talked about, and the ones that I looked at, because I've dealt with it in Whanganui, is the creation of scenic reserves. So we're looking well ahead in your submissions, but you know, since I've brought it up, the ones you've talked about are hardly mentioned by the claimants themselves. The ones that the claimants particularly talk about going through it is the Wairua Falls Scenic Reserve and the Naiatonga Scenic Reserve, whereas the ones you've talked about are ones that have all, in fact, in one case, have been removed out of the tribunal's jurisdiction. So I just think it leaves us with a little bit of a difficulty.
That's accepted, Dr. Anderson, and as I reiterate, what this submission does is go through the generic claimant submissions and responds to each of those matters. The generic claimant closing submissions refers to numerous Public Works Act takings, and this submission matches that.
All right, well,
So of course, I accept that the Crown hasn't responded to the specificity of those two examples that you note. That, as I say, that there just hasn't been the time for us.
So, Mr. Irwin, I was just wondering, in your submissions, did you select all the cases of Mr. McBurney that you have issues with, or was that not part of the reason why you selected them at all?
But we've gone through the generic claimant closing submission and,
Yes.
and responded to those.
Yes. So there is. Yes, I see. So you did that systematically. And I had wondered whether there were, in fact, issues in the tangata whenua evidence that perhaps you hadn't responded to because you didn't feel the need to comment on them at this stage, but is that not the case?
No, that's the issue I've just addressed with Dr. Anderson.
Yes.
So where I'd like to begin, I do realise, Your Honour, that we may be making up some time with issue 10. Even so, I would like to make some headway through this. I don't intend to take the tribunal through the entirety of this document. I would like to move to page 15, if I may.
Probably just before you move to that page, because how I see your submissions being, the basis of them is, one, you, am I right in saying that you don't agree with the findings in the Waitarapa report in regards to public works?
Yes.
Where they set down certain criteria
Yes.
upon which public work takings can be measured. And so at page 10, oh sorry, no, it's at page 12, you say in paragraph 36, here's criteria upon which public works takings can be measured. Because part of the issue that you have with the Waitarapa criteria is that on that measure, nearly all takings would be considered to be in breach of the treaty.
Yes.
And so you've come up, well, you're submitting to us, here's different criteria upon which we should measure these takings. So my question is, given in the Waitarapa measurement, nearly all takings would be considered to be in breach. on your criteria, the takings that you've looked at, other than the ones that we have no jurisdiction to consider, how do they measure up?
The Crown's unable to reach a conclusion that there is a treaty breach in these examples. The Crown, this is an issue potentially similar to the Native Land Court. The Tribunal and the Crown have, in a number of these district inquiries, reached their own different views about the nature of the topic. And so what I've done in the submission is set out in the pages that actually follow from page 12, pages 13 and 14 in particular, the particular questions that the Crown goes through where it looks to see if there's a breach of the treaty in terms of a Public Works Act taking. Crown says that it really is a case-by-case assessment. You do need to look at each individual taking, and I've set out there the Crown's approach. And as I say, throughout the examples that we've reviewed, we're unable to reach a conclusion that the treaty's been breached or its principles.
But if they were measured upon the Waitangi criteria,
Well,
on your submission, they would be. Oh, they'd be considered to be breaches. Well, potentially.
Well, that's an issue for the Tribunal. I mean, if the Tribunal's point of view is as simple as any Public Works Act taking as a breach, these are all Public Works Act takings.
Well, that wasn't the criteria in Waitangi.
No.
No.
So I'm coming at it from a different point of view to the Tribunal. But I still have some very valid and important points to make, and let me make them. Starting at page 15. And I have a big heading there.
I thought I'd save us some time, Mr. Irwin.
I have a heading, generic closing submissions, and the simple point of this period of time underneath that is the period 1840 to 1862. I don't think that that's a relevant period. I don't think any taking in this district occurred during that period of time. There's no example, and this whole issue is something that really happens after that period of time. But the first kind of potential taking of Māori land for public works would have possibly been through the 5% rule, which I come to on page 16. I suspect that the 5% rule is fairly well understood by the Tribunal. My paragraph 45, the first taking of Māori, first taking of land from Māori for public works in Northland may have occurred through this rule. It was a rule that allowed the Crown to take up to 5% of land for the purpose of roads. The rule originated in the Native Lands Act of 1862. The rule was that when a Crown grant was issued, 5% of the land could be taken for a road. The rule didn't apply to Māori only, it applied to whoever held the grant for a certain period of time. If the rule was applied in Northland under the 62 Act, we don't know how much land was taken, whether from Māori or non-Māori. Under the Act of 1865, there was a period of 10 years after the grant was issued, allowing the Governor again to take up to 5% of the land subject to that grant. And again, that applied to whoever held the title of the land at the point that the land was taken during the 10-year period. If the land was sold by Māori to non-Māori within that period, then the rule entitled the Governor to take land from the non-Māori owner. And so just perhaps pausing there, it's not a rule, it's a rule that has its origin in the native land legislation, but that doesn't mean that it's a rule that's applied only to Māori, of course. And as just turning the page, Mr. McBurney said that the rule proved, quote, particularly onerous, end quote, in Northland.
So where are we?
Just turning the page, I'm at paragraph 48. The Crown does not accept that the 5% rule proved particularly onerous or that we can reach that conclusion. Down to paragraph 49, Mr. McBurney said he did not know how much land in this inquiry district was taken under the rule, and without knowing that fact, we cannot draw any inference about whether the taking proved onerous or otherwise. And we don't know how much or to what extent the rule was applied to Māori as opposed to non-Māori owners in this inquiry district. So we can't say proportionately the 5% rule was applied particularly to Māori as opposed to non-Māori, or it was applied in an onerous way to Māori in that regard. Just turning to my paragraph 51. Cannot be assumed that Māori or anyone else opposed the taking of 5% of their land without compensation for the purpose of providing access to their land. Whenever a block is surveyed or petitioned, there's an obvious and important need for access to be provided to it. Usually, though not always, the only people to benefit from the road being laid out are the owner or owners of the land to whom the road provides access. Where title to any road or access way remains with a private individual, the cost of forming and maintaining any access road remains with that individual or individuals. While the taking of 5% of a block of land for a road diminishes the size of the block by up to 5%, access to the road increases the land's value. And I say there, from a commercial perspective, land with access has more value than land without, something with which Mr. McBurney agreed. And when I say commercial access, I really mean economic. From a commercial perspective, I really mean from an economic perspective. It's just that in my cross-examination of Mr. McBurney, I phrased the question as being from a commercial perspective.
Excuse me, Mr. Irwin. I take what you're saying, but the context is that this assumed that Māori were going to retain the land to benefit from that access, doesn't it? And
yes.
In fact, that often didn't happen.
But then they gained, but if you're looking at it in that way, and at the moment we're looking at this from an economic perspective, Māori gain the benefit of the increased value of the land. How can they sell,
Can we just hold the comments, please?
how can they sell landlocked land? No one will want to buy it. So if they go through in the late 19th century, go through the native land court, say up to 5% of the road is taken from their title and a road is laid out that they don't pay for, and they wish to sell that land for whatever reason, then they gain the benefit that the road provides through their sale, through the sale price.
Do you think, do you think in some ways Māori are suffering a sort of a double whammy, that they're expected to give up 5% of their land to make it more valuable, but they're also expected to take low prices because that's part of their contribution to the same thing, to the development of their land?
Well, it depends on the point of time that you're talking about. And so if we're talking about that period of post-1865 or say through into the early 20th century, there is by and large a market for Māori to sell their land. So the point being that they don't necessarily have to sell at a low price, and at this period of time they can sell to somebody who's willing to pay a proper market price for it.
The other thing that struck me, you brought up the issue of landlocked blocks, and so we have a system put in place that's meant to prevent that happening, and yet it seems to happen fairly frequently. Mm-hmm. Do you have a comment on that?
As a general comment, I'd possibly make two comments, Dr. Anderson. It does, the problem of landlocked land through into the 20th century, which is I think where in this inquiry it seems to have become more of an issue, tends to show the need for this kind of rule being applied. So that's my first comment. And my second comment is I recall some of the evidence we've seen in this inquiry of petitions, particularly in, say, the middle of the 20th century. I'm just thinking of some landlocked land, some blocks. We had an inquiry, a hearing in Whangarei, and the lands in question were just to the south of Whangarei. I can't remember the names, I'm sorry. And I seem to recall that there was a block. It was petitioned. It was a fairly simple petition. There were essentially a large rectangle was made into 4 adjoining rectangles. And at the time of the petition, Māori owners are putting through the petition that they're choosing to decide how their interests are to be recognised in the title in this way. They don't provide for a road, but at that time, when different families have interests in the blocks, they continue to through their relations to gain access to the blocks that are actually landlocked. And the problem becomes when the owners of one of the other blocks sell the land to a farmer, and then the problem for the landlocked block owners becomes they have to rely on the new farmer. And I seem to recall the evidence was that sort of was okay. But then that new owner sells on again, and it's a constant issue.
Yes.
And, I mean, the difficulty has to be, doesn't it? The thing that occurs to me is, it's a hard question for me to put, but why didn't the owners put in a road at that time? The time of the petition.
The other question is why didn't the court help facilitate them to put that road in?
And possibly that issue goes to the first point I was making. It does tend to show the need for a rule like this.
All right, well, there's a lot to think about there. Thank you.
So coming to paragraph 52, Mr McBurney's evidence is that Māori settlers were happy for the government to take up to 5% of their land free of compensation because having accessible roads tended to increase the value of the remaining 95%. Mr McBurney also accepted that both Māori and non-Māori in Northland had requested the government to provide better roads throughout the 19th and 20th centuries, and he agreed that there may well have been Māori in Northland who were happy to provide up to 5% of their landlocked land for a road free of compensation so that it was provided with access. Just turning the page. I have a heading there, roads.